here we are. This is a motion by the attorney for Nicholas Robert Rekieta. Now, what they are trying to do here is they are trying to quash or destroy or suppress a motion by one Joshua Moon. And in case you don't know who Joshua Moon is, he is the evil overlord of the Kiwi Farms who owns a drone swarm that will stalk you across all of Europe, America, Asia, anywhere you go. They will find where you are and where you're taking a shit. Joshua Moon. That's Josh Moon. No, but to be serious, Josh had his attorney reach out actually to me, and I filed an affidavit on this as well, giving a motion to allow for audio and video recording because it is under certain conditions presumptively allowed, right? If you meet certain basic conditions, you have to allow this in Minnesota. So Nick is filing this motion, right, in response. But the response is, we want to hide this. All right. So the motion is submitted in response to Joshua Moon's motion for an order of this court permitting the audiovisual recording and broadcasting of all future proceedings in this matter. The defendant objects to the audio and video recording of all future proceedings in this matter and requests the court deny it in its entirety. This is particularly offensive because they're saying under no conditions can this be allowed to slide, right? That's ridiculous. Are there not things the court could do to accommodate for any concerns? Yes, of course there are. So they're going to bring up a lot of things in here. And these are things that they brought up before, which are bullshit. Bullshit arguments like the children, like think about the children. Well, pause. If the children were forced to testify in his criminal case, which they shouldn't be, and by the way, the filming is really only related to the criminal side, not really the child custody side, right? But his kids are not expected to be witnesses. And even if they were, that part wouldn't be recorded. It simply wouldn't because they're children. So as it is, as the law stands, period, that would not be recorded. So that argument of, but the children is a completely bunk argument. Now, they've made this argument before. They're going to make it again, right? But the only way, and by the way, the only way the children get called, the only way that Nick's children get on the stand is if Nick and Kayla put them there. So unless Nick and Kayla are winning Mother and Father of the Century by not only having one of their kids test positive for cocaine, but also by putting their kid on the stand, then they're not even, then there's no way they're even relevant to this at all. Everything involving the kids would be removed. Josh says that through his counsel, authorizing either himself or a professional videographer or a Minnesota attorney to record the proceedings. Moon avers a great word, to be the sole member of a limited liability company which operates the website known as Kiwi Farms. He is the person who runs Kiwi. Yes, he's the person who operates Kiwi Farms. Mr. Moons asserted that Kiwi Farms is an internet forum that promotes commentary and discussion of noteworthy events. And by the way, I see people in the chat saying some stuff about Josh, and I'll say this. You can like or hate Josh. Right? You can think Josh is whatever. You can think Josh is a POS, or Josh is a hero, or Josh is neither good nor bad, or he is a human who has both good and bad to him, right? Whatever you want to think about Josh, right? He's just asking for it to be recorded. So at the end of the day, you can make up your own mind with that information. So that information that you get from that, you can deal with your own way. Included with and in support of Mr. Moon's motion and affidavit were a number of communications to and from Candiota County Sheriff's Office, which Mr. Moon's counsel averred he received in response to his Government Data Practices Act request. Counsel declared that due to the volume of material response to his request and the late delivery of the media, he had not had the time to thoroughly review the records released by the sheriff and what they contain. On August 7th, Mr. Moon's counsel noticed that the court and the parties that Oliver Bromka, a licensed attorney in Minnesota, had volunteered to audio and video to record them on behalf of Mr. Moon. Mr. Bromka's affidavit informed the court that he is an attorney licensed in good standing in the state of Minnesota with Minnesota attorney ID of 0504714. Mr. Bromka reinstated his Minnesota attorney ID was 0505714 in his signature block. However, a search of the Minnesota Judicial Branch website revealed that lawyer ID 0504714 is assigned to attorney Andrea Marie Blastel of Minneapolis, not to Oliver Bromka of Grand Forks, North Dakota. So maybe the guy put the wrong number. Are they trying to like dunk on this guy because he put his wrong bar number? Maybe he just like spelled wrong. It's not really a big dunk. Just saying, like, oh, he got his bar number wrong, bro. That like you spent a paragraph for a typo. Good job, bro. And by the way, you lead with your strongest arguments. So his strongest argument is that the guy who was gonna videotape it misspelled or typoed his bar. That's his strong argument. That's weird. That's really weird, right? That should be like one thing you mention at the end. You're like a little and one, you know. The law. Counsel for Mr. Moon cited the applicable rule, albeit incompletely. Oh, look at that. The cope. Counsel cited to impart the language of municipal rule of general practice, writing in criminal proceedings occurring before a jury plea may be accepted or a guilty verdict may be returned. A judge may authorize the visual or audio recording and reproduction of appropriate court trial proceedings unless there's substantial likelihood that the coverage would expose any victim or witness who may testify at trial to harm, threats of harm, or intimidation, to determine whether to grant a request for visual or audio recording and reproduction. The presiding judge may consider any relevant factors, not including but not limited to the positions of the parties and the wishes of the victim, the level of public interest in the trial, the necessity of coverage to safeguard the defendant's right to public trial or the public's right of access to criminal trials, the existence of security issues, courtroom and facility limitations, or public health concerns, and courtroom facility limitations that would render coverage impractical, the positive or negative impact of recording or reproduction on the dignity and decorum of the trial proceedings, and the effect of recording and reproduction on transparency, public education, public trust, confidence in the proceeding, and the judicial system. Counsel omitted the final sentence, which reads, coverage under this paragraph shall be subject to the following limitations. Two such matters at a minimum are applicable. The first of which, this matter should not be dismissed prior to trial, is there shall be no visual or audio coverage of any witness, victim, or defendant who is a minor at a time of trial, right? Yeah. Okay. Right. And it is foreseeable because of the charge, the alleged violation, Minnesota statute 607-378, one or more of the witnesses called by the state will be a minor at the time of trial. Called by the state? Called by the state? No, the charge doesn't require the kid to testify. What the fuck are you talking about? A blanket order to permit the audiovisual recording for all future proceedings is unwarranted. No, that's stupid. This is a stupid fucking argument. So they're trying to say the state's going to call the kid. Why would the state doesn't need to call the kid? The state has no reason to call the kid. They can prove their case without ever calling the kid. If Nick is doing coke in a house with a kid, the charge is going to be there. The state's not calling him. It would only be Nick. Unless it got to a point so bad that the kid flipped, but I doubt that's going to happen. I doubt a kid is going to turn state's evidence here. Like, if it was that bad, that'd be pretty nuts. That would be pretty nuts. This lawyer is a retard. You just don't show that part. You just turn the camera off for the kid's testimony. It's real easy. It's super easy. You just go boop, boop, and you turn it back on afterwards, right? So you just don't record them. It's very simple. It's not hard. We have the technology to turn the camera off. There is of special significance upon information and belief. The first individual who sought information from Kaneohe County, who identified himself as a volunteer member of the Kiwi Farms Reporting Forum, is John Close of 950 25th Street Northwest, apartment 1813N, Washington, D.C. Upon information, believed John Close, in addition to being a volunteer member of the Kiwi Farms reporting forum. Okay, full stop. This guy self-reported as a member of the Kiwi Farms, except for Josh Moon. Nobody's going to say why oh, I'm a member of Kiwi Farms. The whole point of Kiwi Farms, they can be anonymous. Now, there's advantages and disadvantages to being anonymous. The advantage is that you can say whatever you want to say pretty freely, and nobody knows who you are. But the disadvantage is that people are going to be kind of skeptical of believing you, because if at the end of the day you can't put your identity out there in some way, shape, or form, even if at least your face, right, you do have a little bit less credibility. People don't identify with you. People don't tend to view that you're believable, right, as much if you're anonymous versus if you're not. And also, he says voluntary member. There's no mandatory members. Nobody's conscripted into the Kiwi Farms. It's not like the Gulag, right? Where you're voluntold to go there. So if this case grabs the attention of a convicted sex offender, so this guy is apparently a convicted sex offender, convicted of possession of CP cheese pizza in 2014, so much that he appears to be the first person who sought information from Candiota County Sheriff's Office. The broadcast of these proceedings is fraught with peril as it places minor children of the defendant on display for John Close and other convicted sex offenders. So this does two things. First of all, it says that it kind of implies that all members of the Kiwi Farms are sex offenders, right? That's the implication here. So that's what he's trying to give off here. It's like, oh, all these people that are watching are all sex offenders, and they're just watching to watch children. Well, no, and also the children are not necessarily going to be there, and even if they were, they're not going to be filmed. So real crazy. So who is this guy, John Close, right? Because this is all public information, by the way, guys. None of this is out there. This is out there, and this was filed by Nick's attorney. So once again, Nick's attorney is the one that did this docs, and Nick signed off on this. So I know some people are like, full docs. First of all, Nick's attorney did this. This is public record. So this is me showing what they filed as public record, okay? So let me just be very, very clear on that. So let's see. So here's this guy's offender registry. So let me just show you guys this. So here's this guy. This was filed as Exhibit A, okay? This is John Allen Close on the 900 block of 25th Street, Northwest Washington, D.C. He was convicted of possession of CP in 2014, right? And apparently this guy was like, I read some other places, he's like living on a park bench, and he's got some other issues here. Very, very intriguing character. So this guy wrote to them, to the Candiota County Sheriff's Office in May to request this. Now, of course, that isn't I don't know when he says this is the first person to request stuff, but it's still very, very, very interesting. Now, my theory here was this, that either, number one, this person is like just some random weirdo super fan, or number two, and this is the more weird part, is that this is an op, what we call an op, usually preceded by a G word, but we're going to try to stay friendly on locals, or sorry, on YouTube. But shout out to the locals people. Appreciate all y'all over there. But yes, could it be a G op? Yes, I think in fact this was in fact a G op. If this is true, what may happen here, hear me out. Certain people have been using the all my opponents are PDFs argument since May. I think we remember that argument, right? I think we remember that argument. And, it's very funny that they use that argument. Maybe they use that argument because they literally enlisted a supporter who they knew was a offender to do this. in order to create a legal argument. And some might say, that's crazy, Andrew. Why would Nick ever associate with offenders? He would never do that. He's a family man, right? He's a family man. Turn your attention to Exhibit Baldo over here. This is from AF Trial Streams. 5 years ago, Nick interviewed a convicted sex offender. So we already have pretty solid proof that Nick has direct connections to convicted sex offenders. So it's not crazy to think that he could reach out to some of his sex offender buddies and say, hey, can you do me a solid here? Can you do me a solid? We're trying to create this theory. It's the great PDF file theory. Not a crazy theory. Protecting defendants' minor children is an element that is tangential to the second limitation. There should be no visual audio coverage of any pretrial proceedings, including but limited to bail hearings, arraignment, pretrial, or omnibus limitations, motion in limine, and other things prior to being sworn. Any hearings take place outside the presence of a jury. The matter is scheduled to come forward in contested omnibus. Both the timing of Mr. Moon's motion as well as the request the court permit audio and visual recording of all future proceedings strongly suggests he seeks the court's leave to record and broadcast the contested omnibus, not just the trial, should the matter be dismissed or two. Yeah, I don't think the omnibus is going to be, if this is a law, the one thing I will concede here is if this is an accurate description of law, we may not get the omnibus hearing. We may just get the trial, which would incentivize Nick to settle because the trial is what would be really embarrassing for him. The term shall is mandatory. The court has no discretion to grant its motion for any proceedings prior to the jury being sworn. So they can only grant it for the jury portion. His lengthy analysis is irrelevant. Because the plain language of Rule 4's limitation renders his analysis of general factors superfluous, the court need not consider them. Nevertheless, due diligence requires to be specifically addressed. No, that's not true. And this is his lawyer trying to pass it off with the children argument, which doesn't fly, right? Because he's trying to specifically talk about the rule pertaining to children, right? Which is not what, no, which no, that's not going to fully protect you there. Okay, the defendant does not favor video action. So they're literally saying right now that the defendant does not want audio-visual access. So no matter what Nick wants to say in his filing, which at the end of the day, we judge people by their actions, not their words. People can use all sorts of weasel words and do sorts of things, but we judge them by the way they behave. And he signed off on this. Nick endorsed this. He endorsed a statement that says he does not want this to be televised. He wants to hide. He endorsed that. From silence, Mr. Moon assumed the defendant's position on video access to the court has not changed, so he hadn't received a response. This is a bold assumption, as cited cases upon which defendant has previously opined did not involve this, nor any of the other defendant's minor children. So what they're trying to say is that because literally Nick is making the argument here that because this case is about him, because it's about him, he doesn't want it to be covered. If it's somebody else, it's okay, right? But it's about him. And the other cases he covered weren't about him. And because they're not about him, then it's different, right? Because he's different. He's special. He's a special snowflake that deserves all the exemptions in the world. Hypocrisy. Vile, disgusting, morally bankrupt hypocrisy. You've made millions on other people's trial, millions, and you're going to say you're against it, right? And here's the fucked up thing. Let's read this. Who are the victims? What does Mr. Moon's counsel mean when he says these victims have not specifically expressed any opinion to him? Is Mr. Moon's counsel referring to defendants' minor children? If so, have they expressed any opinion to him directly or through a third party? This is disconcerting given the rapid involvement of John Close, a member of the Kiwi Farms Forum and a convicted sex offender. So once again, he's calling all the Kiwi Farms PDFs. But the implication here is that this is a victimless crime, is that Nick has committed a victimless crime. Nick is making the argument that neglect, use, possession, victimless crimes, right? The level of public interest is conceitedly exceptionally high. So they're going to contest this, right? They're going to contest. It is that exceptionally high public interest, as evident in the defendant's first appearance, which resulted in public interlocutors intruding upon the proceedings, as well as proceedings being recorded by parties as yet known, unknown, and made available on social media. Okay, so they're literally trying to equate a trial with, in essence here, a first appearance. They're two different things. The trial, we've already said, look, the pretrial stuff shouldn't be recorded, but the trial is the public proceedings that everybody should be able to attend if they want to attend, right? The first appearance was just the first appearance, and that was on Zoom. And honestly, the only reason why that got interrupted is because some fucking boomers didn't know how to regulate Zoom. You can literally manually like unmute people and mute people. You can just mute everybody and then only manually unmute people. But it's not the same as a trial. So here he goes to argue here that the Sixth Amendment of the Constitution, a constitutional argument. Where do we think he got those from? He's making constitutional arguments. Queuing up Boss Baby Part 2 here. According to the U.S., guarantee a right to trial by an impartial jury. According to the U.S. Census population, the population, I guess he is assuming, of Kandiyohi County is 48,000 people. Of this population, 24% are under the age of 18 and 21% are over the age of 65. That leaves a pool of 26,847 adults, most from whom to seat a jury. Neither the defendant nor the court can undo the unlawful exposure to which he has been exposed, tainting his potential veneer. But defendant does request the court can prevent the harm to his future right to an impartial trial by not tainting the potential veneer in a venue this smaller than that drawn upon in Chauvin. You piece of shit, Nick. This argument applies to the majority of counties in the United States. If Nick is saying that it's going to taint the jury pool, then every single trial was tainted. Then so was Kyle Rittenhouse. So was Johnny Depp. Every other jury trial was tainted by recording. You really believe that, Nick? That streaming this is going to taint your jury trial? Bro, Nick just said, I want to get back to trial streaming. This is what Nick said recently. There's clips of it. He's talked about it recently. He said, Nick just wants to get back to trial streaming. You dare to go back to trial streaming after you say this? That it violates your right to trial by an impartial jury? Bro, that's sad. That's sad. Let's continue here. The coverage is not necessary to ensure a public trial for the defendant or to protect their right to access. Even if the court denies the motion, defendant's trial should the matter be not dismissed prior thereto, will be public and the public will have the right to attend. Only they may not be able to attend from the comfort of their recliners in their pajamas. Fuck you. Fuck you. Okay? The point is that there are people around the world that are interested in this, or people that are around all the United States that are interested in this, right? And yeah, not everyone wants to go out to Kandiyohi County, Minnesota. I don't. Nick goes on to compare himself to Trump. Literally, Nick and his lawyer think that he is Donald J. Trump. They're trying to assassinate the king, the Pope. Look what he says here. Earlier this year, Donald Trump was tried by a jury in Manhattan. Despite the international interest, the inability of those accredited journalists who desired to be physically attend and offer commentary, President Trump still had a public trial, and the public had the right to access, even though proceedings were not recorded and broadcast. Well, so he's not just calling himself Trump. He's not just calling himself Trump, ladies and gentlemen. He's saying that New York law should be the law of the land across the United States. Because that trial happened in New York. Nick is saying that the authoritarian communist rules of New York are good law for all of the United States. He's pro New York here. Bro. And you're Mr. pro rights and liberty, and come on, bro. Like, this is insane. It's nuts. While the defendant does not claim to garner the same interest as the former president, I'll take that step back there, huh? And recognize it's a different jurisdiction venue, the general rules should be universal. Literally saying, take New York law and make it universal. Oh, wow. The Pope. How far the Pope has fallen. This is like, when you catch the Pope, you literally catch the Pope in like the scullery, like banging maids, but the maids are dudes, and the flower is really Colombian marching powder. That's this situation when it comes to Nick Rekieta. It's sad. It's sad. Security issues and facility limitations do not require broadcasting. Counsel for Mr. Moon says there might be overwhelmed by thousands who desire to attend. Mr. Moon's counsel may have well demonstrated there's interest, but has offered no evidence to support any assertion that thousands of those are interested enough to transmit a data request or sign an online petition will flock to Cañon County Court, overwhelming the facilities. Even if every individual who took effort to execute affidavits elected to attend in person that would not fill the court. Literally, there were only 7 affidavits, you idiot. You expect signed affidavits from thousands of people? No, that's stupid, right? Yes, Candiota County has 7 seats, but I bet they don't have 300. Mr. Moon's counsel offered no argument to support in his conclusory statement that security is beyond the measures of Candiota County sheriff's deputies who secure the courtroom. I think that the sheriffs could probably handle it, except for there'd be too many people. I think the facility issues is the bigger thing. Mr. Moon's counsel is aware of no technological or other infeasibility of granting this request to audiovisually record and broadcast. Mr. Moon's counsel does not aver that to know if the facilities are conducive to the method he proposed. The method is simple. Press record, bro. I'm sorry, but like, it's not hard to record stuff. We're in 2024. You know what recording involves? Hey, I'm recording right now. Look at that. Recording, right? Recording is not difficult. It's not rocket science. That we have the technology. The method proposes leaving open broadcasting for minor children. No, it doesn't. When did Josh say he wants to explicitly record minors? And it's not allowed. This is bullshit. And I hope their counsel responds on this. And it's like, no one is, because they need to just defeat this argument, right? Nobody is asking to record the children. This is ridiculous. Broadcasting these proceedings are unlikely to promote transparency, public education, public trust, and confidence in the proceedings. Guys, he is literally saying, hold on, this last point here. Nick is arguing that streaming trials does not promote transparency, public education, public trust, or public confidence. He is arguing in that last statement that it is a net negative to stream trials. That comprehensively it is a net negative. And you know what he argues here? Look what his lawyer argues here too. He says, these factors were lost when members of the public ignored the entreaties and orders of the court to conduct themselves with decorum. He's speaking about the fucking Zoom hearing that the boomer judges didn't, like the boomer staff didn't even know how to operate properly, right? So literally they're saying when they spoke up and they were rude during his first appearance, they lost it. So if we allow recording, it's like punishing a child who raided the cookie jar by giving them the rest of the cookies. What type of fucking dumb shit did Francis Herbert White III here cook up in his fucking meth basement with that one? Well, they misbehave, so don't give them what they want. It's insane. And this is, once again, Nick Rekieta had to endorse that motion in its entirety. If he did not endorse that, his lawyer could not legally file that. If Nick did not endorse those arguments, it could not be filed by his attorney. So he must have endorsed that argument, endorsed that line, that strategy, right? Now, who's influencing that? I'll leave that up to you. But I think it's been a certain theme of theirs to go for the children, which is honestly kind of disturbing. Okay, Hako says, Nick is doing exactly what True Crime Karens did to him when he was covering the Sophie Long case. What a scumbag. Look, listen, if there's one thing I don't have much tolerance for, it's hypocrisy, right? It's when you're going to do one thing and then and especially when you're like going out here and you're pretending to advocate for one thing and you're going to do exactly the other. And your actions even now, they're saying, I want to still stream. No, you should be disavowing trial streams. What Nick needs to do now is say, what I did was wrong. I should never trial stream. Trial streams are horrible. I'm never going to trial stream again. They violate the rights of defendants. They're against the Sixth Amendment. They're against, they don't support transparency. They're horrible. Do not stream trials. I agree with Netflix, the Netflix documentary. I agree with that about the Johnny Depp trial, because the whole point, by the way, the Netflix documentary of the Johnny Depp trial was that streaming the trial was bad and it shouldn't have been streamed, right? So saying, oh, I agree with that. Shut it all down. Shut it all down. That should be his point. He should say, oh, I've stopped. I've cut it off. That's consistent. And if he does that, okay. I mean, I'm still not going to like compliment him too much, but at least it's consistent, right?